that EquiSearch has acted as an agent of the state in this matter. They have gone on record numerous times, and I'm sure the court can take judicial notice, of claiming to be working with law enforcement. In addition to that, they were paid by law enforcement. There were law enforcement officers numerous times at their search locations. I think is quite clear in this matter. So unfortunately, Mr. Nijem's response doesn't address that issue. In addition to that, I think Your Honor can issue a subpoena, and then we can then take that to Texas and ask that it be enforced. Should another jurisdiction decide not to enforce it, that would be an issue that we'd have to resolve in that other area. I think the court should also consider and look at that this agency availed itself to the state of Florida when it chose to come here and transact business. When it chose to accept donations, and I believe they've even claimed to have been or open up an office here in the Central Florida area. So you can't avail yourself to a jurisdiction and then claim that you can't be touched by a subpoena. I think that's Civ Pro 101.
I'm going to take a look at the cases, and I'll take this under advisement and decide it later today. I think the deal is doing business is, I don't know if that is appropriate here since they're a nonprofit and they're a Texas nonprofit. Having said that, if you have any, you make requests in your application, and again, it's not that the evidence isn't relevant. That's not really the issue here before me. So if you have any cases that support your position, get them to me by noontime, because I'll do an order on this afternoon.
Your Honor, if I may be heard briefly.
Quickly, yeah, go ahead.
Thank you, Your Honor. As it relates to the lack of responsiveness, there was nothing alleged in the pleadings. One can't respond to what was never alleged in the pleadings in the first place. One cannot simply go out there and say they're an arm of the state of Florida. It's not even alleged in the pleadings. So how in heaven's name can anybody address something if defense doesn't even set forth the grounds? We're not mind readers here. The fact of the matter is there's a right and a wrong way to do it. This was done completely wrong. If you could even overcome that, we have other issues as far as the ability to finance it and all that, which we'll address if they can overcome the initial burden.
Get me anything else that you want to get me by noon or shortly thereafter. And if you don't prevail on the motion, it'll be denied without prejudice. You can always refile, but I'll rule on it today. But get me, you've handed me the cases I think you need.
Which are all the cases in our memorandum, Your Honor.
I'm good with that. But anything else that you're going to send me on this issue, I'd like by noon, okay?
Thank you for your consideration, Your Honor.
Yes, Judge, I'd like to respond briefly and get one or other matter on the record.
On this?
Yes.
All right, briefly.
Okay. I have a hard time believing that Mr. Nijem has not been following this case. Specifically when we're talking about the allegations or the possibility that these may be agents of the state, and I'd like to approach the court with a exhibit, if I may, in response to one of Mr. Nijem's allegations in reference to paying. I think they addressed or criticized the defense about not paying for certain tips. Attached is an email from the lawyer, Miss Anne Marie Delahunty, from Orange County Sheriff's Office, where she admits that some of those tips were not in conformity with what we asked for and what our specific request was, which is what's been debated all along. So I just wanted that to be, should the cost issue come up. I know Mr. Nijem was not privy to that information, so perhaps that's the reason why he made those statements in his motion to strike.
You can respond to this later.
I need to respond to one other thing, if you'll allow me 1 brief minute. It won't take any longer than that, I promise.
Okay.
I attempted to hold back on it. I didn't think this was the appropriate forum.
I see you sat for almost 20 seconds.
All right, thank you. That's a record for me. Your Honor, since the defense attorney comments that one must have familiarity with it, he clearly has familiarity with the fact that I represent Texas EquiSearch. I am baffled why he was then contacting my client directly without going through me. And accordingly, I held back on that because we were wanting to find out if in fact he was aware that we were in fact representing Texas Equisur. Since he's obviously following it and made a suggestion that one should know, he's been in direct contact with my client without my authority, approval, or knowledge until after the fact about attempting to seek the very records which he's in court for today. His Honor is well aware of the inappropriateness of that, and so all matters should in fact go through counsel and not around counsel.
Having dealt with that, then we're off topic now. He's requesting the records listed in his motion through subpoena ducis tecum. I'll rule on that later today. Once again, anything that you're going to get me on that issue needs to be to me by noon. We have then...
Judge, if I apologize. I think I'm under the duty...
hang on. Are you still arguing the motion that we just dealt with?
Not directly, but I feel I have to respond.
Well,
to...
there's no need. There's no need. None of that has any legally... I understand his point. I understand your point. My time is limited. So, again, I will consider your motion. If you have anything that you want to send me that buttresses what you said there, send it, and I'll rule this afternoon. If you want to write down anything else, send it to me. Again, our time here is kind of limited this morning.
I understand, Judge. As an officer of the court, I feel I do have to advise a possible violation of Rule 4-1.9 of the Canon of Ethics. Mr. Nejam represented both Cindy and George Anthony previously, and the Anthony's family had requested this information from Mr. Miller directly.
Let me stop you. You're basically sort of filing an ora tennis motion in court. He hasn't heard this. If you want to make, whether it's a bar complaint or put the court on notice regarding some ethical violation, put it on paper, send it to me. But that's not noticed for today. Okay, we're just...
What I'm just saying is, I think it's my specific duty to advise the court of that issue.
You've done so.
I wouldn't be doing any filing of any bar complaints or anything like that.
The court's on notice. Let's go then.